Hello everyone, Jeff Marion again, and welcome to my YouTube channel where we're going to help you navigate a personal injury lawsuit. Today's topic is going to be what makes a good personal injury lawsuit. The second issue, or the second part of a good personal injury lawsuit, is that you need liability. That means that you need a party that's clearly at fault. If you're talking about a car crash, that seems to be the common one. A car crash is going to be somebody who runs a red light, runs a stop sign. Yes, a rear ender because that's somebody who followed too close or couldn't stop in time. Moving out of a lane unsafely. In most cases, the person who caused the crash may be ticketed by police at the scene. So making sure and getting the police report and seeing if any tickets were issued is very important in determining liability. If you're talking about the slip and fall kind of case, when we're talking about liability, it's that the landowner knew about the condition and had time to fix the condition and didn't, or created the condition in the first place. So there has to be that notice. It can't be sudden snowfall or sudden freeze and the person falls on ice. There's got to be ample time or evidence that the landowner plowed the parking lot but missed that area, or didn't plow correctly, or allowed water from a drain pipe to run off without salting. Anything that along those lines. But you need to have a very clear case of that. The product liability case, what you need to have is you need to have a knowledge that the company knew that the product that they were putting out into the marketplace was defective or would cause this injury. Circling back to the McDonald's hot coffee case, what McDonald's knew is that at the time that this woman filed her lawsuit was that they had had hundreds of scalding incidents, including small children. And they knew that their coffee was that hot, so hot that it would cause these injuries. So that knowledge then creates the liability. In a case of, for example, years ago, Ford had a car called the Pinto. And what would happen with those cars is they would explode in rear-end collisions. The reason they would explode is that the back bumper had a rivet, a single rivet holding it on. And the rivet was large enough that in a rear-end collision and the back end crumpled, the rivet would puncture the gas tank, which would create the spark which would cause the vehicle to explode. Now, a 7-cent bladder rubber bladder attached in between the rivet and the fuel tank would have prevented this from happening. During the course of the lawsuit, the attorney representing the people who were killed and burned to death in the crash found information and found documents from Ford Motor Company where they said, yes, we could attach this bladder at 7 cents per unit or thereabouts, but the amount that we'll pay in lawsuits from people who die in these crashes will be less, so we should just go ahead and leave that out. Do companies make decisions like that to this day? Absolutely. Another current example is the opioid litigation. And what we found out is that basically they took the science of opioids, which we all knew, opioids, opium, heroin, it was all addictive. Morphine, also addictive. And then created a whole science, I'll use air quotes there, science, that said that as long as a doctor prescribed these pills to you, you couldn't possibly become addicted, which flew in the face of hundreds of years of medical science. So they knew that these drugs were addictive, but they figured a workaround in order to get them into the marketplace and make them the dominant painkiller prescribed by doctors all over the country. So that's really, when you're talking about a product case, it's the what did the company know and when did they know it? So that's really what you need, is you need liability. Now, to sum up, when you're talking about a car crash, you need to have the other driver at fault. In a fall case, you need to have a condition that was either created by the landowner or the landowner knew about and did nothing about. When you're talking about an unsafe product, that the company who produced the product knew that it was unsafe and still sold it to consumers anyway. Does that mean that it has to be 100% liable? No, it does not. In New York State, we have what's called comparative negligence. Comparative negligence means that a person can be at fault and sue, and it doesn't wipe out the claim. So in a car crash, you may be 10% at fault. That doesn't bar you from suing. Now, there are states in the union that have what they call contributory negligence. And that means if you're 1% liable, you're out the door. You can't sue, you're barred. But here in New York State, we have comparative fault. So what that does is if ultimately you do receive an award from a jury, the jury can say, okay, well, plaintiff, you were 10%, 15% at fault, so that reduces your award by that percentage. So the fact that the other side isn't 100% liable in New York State is not a bar to recover. I want to thank you for taking time out of your day to watch this video. We do them every week, so we'll have videos up every Sunday. Please like this video, and please subscribe to this channel. Also, if you're interested in more information about any kind of lawsuit, please check out my website at www.jeffmarionlaw.com and go to my Facebook page, www.facebook.com/JeffMarionLaw, and like my page, and you can get more information there. So we'll see you next week.